Aloha, this is Professor Porter. We're talking about the federal rules of evidence, in particular hearsay. And this is under Article 8, under the hearsay rules, the policy underlying them. We covered in earlier videos and likely earlier on in your evidence studies, you covered policy rules like 407 to 411, subsequent remedial measures, offers made during a compromise, statements offered to pay medical expenses. And it was really clear at that time that the reason why we had to come up with those rules is there was some type of public policy reason. And one of the things that you can think of to back up a step before you get into all the ins and out of hearsay and the evidentiary arguments under hearsay, and certainly all the exceptions and exemptions and the different ways that a hearsay argument can go, is to always keep in mind what's the policy underlying hearsay. Why do we have hearsay rules? Why do we make this a big deal? Why is this an objection at all at trial? Because if you keep in mind those policy rules, either from the perspective of the opponent, the one who's doing the objecting, the one who's standing in opposition, you can say, this meets those policy rules. You got to keep this statement out. You got to stop the proponent from doing what they're doing because this also violates the policy. So it can make its way into your analysis. It can make your way into a good essay answer after the word because. And same thing for the proponent. If you are the one asking questions, presenting evidence, putting on evidence, and all of a sudden an objection hearsay flag is thrown in the middle of the courtroom and you're making your way over to sidebar, keep in mind some of these underlying policy reasons and why they might not be implicated or at issue here with this evidentiary debate. So really it comes down to a reliability. We always want to value firsthand accounts over secondhand accounts. First-hand accounts allow us to test the reliability of the statement, the trustworthiness of the statement. If you are a witness and you've said something outside of court, and to bring you in and to ask you firsthand, what did you see? What do you know? What is your testimony here today? Right? As soon as we start to say that firsthand account, that witness that's called is going to recite something that someone else said earlier, someone else said outside of court. Essentially, a witness on the stand is quoting a declarant out in court. They are bringing in that quote, bringing in that person's quote bubble and making it part of this trial. Well, we suffer and it lacks from some reliability and it lacks from some trustworthiness. When we have the person on the stand, it's better and it's historically been proven to be better, and this came on from the common law. And it's why we made hearsay a rule based on these policies. We want firsthand accounts. We want the proponent to go through the hard work of getting witnesses with personal knowledge to come in here and talk directly to the jury. So it's about reliability. That's all hearsay is about, and it's about trustworthiness. And really it has to do with two foundational principles that you can go to and that you can have as part of your argument. We want opposing counsel to have the opportunity to cross-examine. If they're going to talk about something that's in their testimony, we want to be able to cross-examine that witness. We want to be able to cross-examine that person who makes their way to the stand. And of course, in constitutional concern, that's called the opportunity to confront, like we see in the Sixth Amendment's confrontation clause. The second thing we want to test reliability, to test trustworthiness, particularly of statements, is the opportunity for the jury to evaluate credibility. Now just imagine if we only have a witness and a firsthand account, well then opposing counsel at some point during that testimony is going to get a chance to ask their questions. They're going to say, okay, you told us what color the light was on that day. Let's talk about the weather conditions. Let's talk about your eyesight. Let's talk about what sunglasses you were wearing. They can ask cross-examination questions that can maybe chip away at and impact reliability. Whereas if it's a person bringing in the quote bubble of someone else, a declarant that we don't get to meet, you can ask the witness some cross-examination questions, but we really don't get to explore those things as it relates to the declarant, the one who's saying. So essentially, someone's able to offer testimony at trial. This declarant words are coming into trial, but it deprives opposing counsel of the opportunity to cross-examine or confront that person. That's a big deal. To let someone's quote bubble without requiring them to show up deprives cross-examination, and that can make your way into your arguments having to do with hearsay. The second thing is when it's a first-hand account, the jury can obviously evaluate the credibility of that witness. That goes for everything. the way they answer, the tone they use, the pauses they have, how much they're sweating on the stand, all of that goes into our human ability to naturally look at someone and evaluate their believability, their credibility. Are we accepting what this person's offering? Well, same thing. If I'm a witness that comes in and I'm bringing in the quote of someone else, I'm bringing in the quote bubble of a declarant, the jury does not get to meet that declarant. The jury doesn't get to meet the author of that statement, the owner of that quote bubble. And they don't get to see all the same things. They don't get to hear them speak. They don't get to see them sweat. They don't get to hear the tone of their voice or the pauses between the question and the answer. So just think, the first-hand account really has to do with reliability and trustworthiness, and that breaks down into these two things. We want the jury to be able to evaluate credibility and to meet the people that are going to offer evidence against us, and we want the opposing counsel to be able to probe and explore and ask their own questions and cross-examination to confront those witnesses. Bringing in hearsay, letting secondhand accounts, falling asleep at the wheel as an opponent and allowing a witness to say what a bunch of other people said outside really deprives the jury and the trial of this important function of testing the reliability of all evidence. Further to the policy, if you really think about hearsay as quoting and what is the witness on the stand doing, especially if they're quoting, and you've got to pay attention to the questions that come from the proponent. What did so-and-so say if that so-and-so is not the witness on the stand? After speaking to declarant, what did you learn? Just smuggling in a quote, a statement from someone else. And it's really about, you got to look out for, and the issue spotting comes down to quoting yourself and quoting others. And sometimes it's just advocacy, especially when it comes down to quoting yourself. A statement by the witness some earlier time, if I'm the witness and I'm quoting myself from earlier, it's going to be hearsay. So just think about, I'm a witness because I was standing on a street corner and I saw an accident. I'm called as a witness at trial. And of course I gave statements that are closer in time. I gave statements to the insurance adjuster. I gave statements to the police. I might have given statements in a deposition. I gave lots of out-of-court statements. And if you're the proponent, if you're the one that called me as a witness, you have to have a contemporaneous conversation with me now. As you're standing on that street corner, kind of first person, what did you see? What color was the light? Describe the cars coming into the intersection. Who entered the intersection against the light? You're having a contemporaneous conversation. That is going to survive hearsay. That's not going to involve quotes. But notice, if you're not thinking about hearsay as you're presenting it, you could say, right after the incident, did you have a chance to talk to the police officer? I did. What did you say to the police officer about the color of the light? What did you tell the police officer about the cars coming into the intersection? Same type of question, same content, really just phrasing, really just perspective. But if you start quoting yourself, I told the police officer the light was red, objection, hearsay sustained. What color was the light when you were standing there that day? It was red. Objection, hearsay, overruled, and you get to get into it. So don't quote yourself and don't be so obvious as to quote others, because then as a proponent, you will be in a place of responding to a hearsay flag thrown in the middle of the courtroom. Objection, hearsay comes from your opponent, making your way over to sidebar. You'll have to make a definitional argument that this is not hearsay, it's not a statement, or the most popular one, that it's not offered for the truth of the matter asserted, it's offered for some other purpose. Or you'll have to go to definitional arguments of your own under 801D that we cover in a different video, or the whole world of exceptions, either reliability exceptions under 803, necessity exceptions, unavailability exceptions under 804, or maybe the residual exception under 807. You'll have to go to this whole other patchwork of what's going on, or you can be very careful not to quote yourself or quote others. And really it has to do with thinking of your prior testimony and prior statements. Every witness, when they testify, has most likely given some prior statement, has maybe even given prior testimony, especially if you include depositions in civil cases. So just think, that's a safety net. That's in the event that they lie and you need to impeach. In the event that they do not remember and you need to refresh, you can go to those prior statements for specific purposes and when you have the foundation laid. But otherwise, it's a contemporaneous conversation right now about what they know, what they saw, and what they can test to within their personal knowledge. We want first-hand accounts instead of second-hand accounts. That's the most important part as it relates to policy. So if I'm talking about my own experience, I'm giving a first-hand account. If I'm saying, like a news reporter, I had a chance to talk to 3 other people at the scene, person 1 said this, person 2 said this, you've now turned yourself, even though you were there, you've turned yourself into a conduit for secondhand accounts. You are the one just basically sponsoring those other conversations. And think about it with policy. I don't get a chance to, if I'm the jury, to meet those first, second, and third people that you talked to and interviewed at the scene. I don't get to, if I'm the opposing counsel, I don't get to cross-examine those people. Those are our main 2 big policy issues. And that terminology, keep it straight all the time. It's worth some annotations in an essay if you're working through this. The witness is the one on the stand. They're the ones doing the quoting. The declarant is the person who has the quotes attributed to them. They're the ones that's being quoted in the courtroom. So sure, there's sometimes when the witness and declarant are the same person, but I still cannot, as we talked about, quote myself from some earlier statement, from prior testimony, or some statement closer in time. I need a contemporaneous account, and I certainly can't quote others. So the witness, if they're going to quote a declarant, you as the proponent are going to be doing the hard work to make a non-definitional argument, an 801D argument as to why it's an exemption and not hearsay, or one of the many, sure this is hearsay, but an exception applies under 803, 804, and the residual exception of 807.